Hello, my name is Jasvir and I'm a partner in the Gowling Restructuring and Insolvency team in the UK. It's good to be able to talk to you today about a significant piece of new legislation in the world of restructuring. My talk has been prepared specifically for General Counsel team members, in-house lawyers, and provides an overview on generally on the terms that you need to know under this new act. It's not prepared for restructuring insolvency industry clients, for which I would need to prepare a much more detailed session. So with the onset of COVID-19, a number of initiatives were brought into effect to suspend creditor actions, suspend wrongful trading claims, suspend hearing winding up petitions, and there were commercial rent holiday provisions brought into play for all for a period of time. In amongst all of this, and not necessarily because of COVID or related to COVID, new laws were also brought into effect and were introduced, providing for a new restructuring moratorium, court-led reconstructions, and wider prohibitions on terminating supply contracts. So all of these new measures, these permanent introductions into our into statute, was brought about by the Corporate Insolvency and Governance Act 2020, CIGA. The Act came into force on the 20th of June 2020 and the 25th of June 2020. I want to talk specifically about the new restructuring moratorium introduced under the new Act and say a little more about the prohibitions on terminating supply contracts. So the Act, as I said, came into force in June 2020, but there was talk long before that in the restructuring community that the UK needed and was missing a process by which the directors of a company in distress could have the room to assess the company's viability without the need for that company having to go into an insolvency process straight away, like a company voluntary arrangement or administration. This new Act has brought into force for the first time in the UK a freestanding, standalone moratorium as a way of offering protection to businesses that face difficulty trading due to cash flow insolvency. The aim of the moratorium is to allow a company in financial distress that breathing space to explore, rescue and restructuring options without the directors and the management team feeling the pressure of creditor actions. So really, in summary format, over the next 20 minutes or so, I'm going to try to bring out some of the key changes brought about by this new moratorium procedure, and which may directly affect the assessment of your customers, the counterparties to which your organisations have commercial contracts with, and just may start you thinking about what type of risk exposures, what types of checks and balances you ought to have in place, given that there is now the ability for companies, counterparties, to apply for this moratorium regime. We will look at which companies are eligible to apply for the moratorium, how that is done, what it means if one of your contract parties is in a moratorium, has a moratorium in place, what can and can't be done when a company is in a moratorium. What's clear is that the new process, the process for this new moratorium is meant to be a streamlined and quick process, and it's not necessary that the directors have at the outset the outcomes and the objectives that this moratorium is trying to achieve. The moratorium, this process, this procedure is designed to provide that breathing space, the freedom to allow the directors the time to consider what those outcomes and objectives could be for their company. So we're looking at which companies are eligible to apply for the moratorium. As a general rule, a company will be eligible unless that company is specifically excluded from applying under the new Act. And the new Act lists a number of exclusions a number of companies, number of institutions which are specifically excluded from applying for the moratorium. And these include institutions like banks, insurance companies, money institutions, companies which are party to market contracts, and market contracts are also a defined category under the Act. I mean, if you've got any, if you've got any questions on the exclusions, which companies are eligible, which aren't, then please give your usual Gowling contact a ring or give myself a call. We're happy to go through those with you, but I'm not proposing to focus on those in this presentation. So companies which are not excluded, but which are already subject to some form of insolvency process or have been subject to an insolvency process in the 12 months before applying for a moratorium will also be ineligible. So a full list of the ineligible companies is provided for under Schedule ZA1 of the new Act. So how is a moratorium obtained? The new Act requires the directors to file certain prescribed notices and statements with the court. These statements include that the company is eligible for the moratorium, that the directors wish to obtain a moratorium, and in the director's opinion, the company is or is likely to become unable to pay its debt. So it's likely to become or is cash flow insolvent. Also required to be filed with the application is confirmation that the monitor, a monitor, is assisting the directors with the moratorium. And this concept of monitor is new, but essentially a monitor is someone who is a qualified insolvency practitioner and who agrees and consents to act in relation to the moratorium. The monitor also has to file a statement that in his or her opinion, the moratorium will result in the rescue of the company as a going concern. So just to bring out a couple of key points there, the monitor has an overseeing role. The monitor is not in control of the company. The directors remain in day-to-day control of the company, and they make the decisions in relation to the company, and the moratorium envisages that the company is able or will continue to trade during the period of the moratorium. Also to note is that there isn't, it's not, a court hearing isn't needed to put the company into a moratorium unless there's a winding up petition that's been issued. So once the notices and the statements have been filed, the company's in a moratorium. The monitor has to notify the registrar of companies that and all creditors that the moratorium is in place. It is more than likely that this will be the first time that your organizations will hear that one of your customers or suppliers, counterparties, is in a moratorium. So the notice has to state that the date that the moratorium started and when the moratorium will end. The moratorium will last for 20 business days, starting with the day after it came into force, unless it is terminated or extended. So the company, the directors and the monitor can extend the moratorium for a period in addition to 20 days, with or without creditor approval. But also the moratorium can be terminated before the end of the 20 business days if the directors decide it's better to go into an insolvency process. So if you remember, the moratorium is designed to give the directors that breathing space, that freedom to make the decisions that they need to make without creditor pressure. And it may well be that they decide that having had that time, that they think that actually the company can't avoid an insolvency and therefore needs to go into an insolvency process. So if that's what the directors decide, the moratorium ends and then an insolvency process follows. The monitor, so the insolvency practitioner, he or she can also end the moratorium if the monitor thinks that it will no longer result in the rescue of the company as a going concern, or if that rescue has been achieved within the 20 business days. And the monitor can also terminate the moratorium if he or she thinks that that they can't carry out their functions because the directors are not cooperating, or the company is not cooperating with the monitor. Also importantly, the monitor will terminate the moratorium if the moratorium debts and the pre-moratorium debts, for which there is no payment holiday, are not being paid by the company during the moratorium. So there's a couple of key phrases in there that have been introduced by the new Act. What are moratorium debts? What are pre-moratorium debts? And what is a payment holiday? Now, I'll come on to explain what these categorization of debts are. It's a key aspect of the new Act, and we'll come on to that a little bit later in the presentation. So what does being in a moratorium mean for one of your customers, one of your suppliers, your counterparties, where you may be owed money by that company? So first of all, whilst there is a moratorium that is ongoing, there are a number of restricted actions. So the Act imposes restrictions on what creditors can and can't do in a moratorium, or against a company in a moratorium. There are also restrictions imposed on the company and the directors as to what transactions and disposals, sales of assets that the company can undertake whilst it's in a moratorium. And there are also restrictions on payment to creditors who are owed money before the moratorium takes effect. So there are restrictions imposed on the company in what payments that the company in the moratorium can and can't make. So the restrictions on the payments that the company can and can't make creates a waterfall of payments to creditors that is, again, one of the key aspects of the new Act. So in terms of creditor actions and what are the restricted creditor actions, what this means is that whilst a company is in a moratorium, if your organisation is owed money by that company that is in the moratorium, insolvency proceedings can't be commenced against the company during the moratorium, except in very limited circumstances. For instance, if the directors themselves want to put the company into an insolvency process. Also, no step can be taken without the court's permission to enforce security over the company's property. So your organisation may have, some type of security interest. You wouldn't be able to enforce that security interest against a company that was in a moratorium. There are also restrictions on and enforcement of legal proceedings, including proceedings brought for rent that remains unpaid. So landlords can't exercise forfeiture rights by peaceable re-entry. No other proceedings or legal process can be commenced during the moratorium except in very defined categories. For instance, if there is already a tribunal claim, employment tribunal claim that is ongoing, or there are claims between an employer and worker that are ongoing, or those claims that you've got court permission to continue with. An interesting aspect of this is where do you stand if you've got ROT, a valid ROT claim, and you want to get your goods back from a company that's in the moratorium? And there's a question mark there because of course the whole purpose of the moratorium is that the company isn't constrained by creditor actions to ultimately decide what it wishes to do. It's to give the company that breathing space to understand whether it can survive and continue to trade as a going concern. So that will be an interesting development to understand what the courts make of ownership rights that you want to assert against a company in a moratorium. Or there may be, if you've got a floating charge over a company that's in a moratorium, you can't take any steps to crystallize that floating charge or impose a restriction on the disposal of the company's property that is subject to that floating charge. But of course, the company has to respect the the charge holder. So the fact that there is security over that asset that it wishes to dispose, the courts will say that the proceeds of that asset need to be paid to the charge holder. So there are also restrictions on the types of transactions that a company can enter into whilst it's in a moratorium. A company can't obtain credit of £500 or more unless the credit provider has been informed that the company is in a moratorium and the moratorium remains in force. This includes in relation to conditional sale agreements, hire purchase agreements, and advance payment of goods and services made in money or otherwise. There are also restrictions on the granting of security during the moratorium. A company can really only grant security during the moratorium to a creditor if the monitor consents. And again, the monitor can only give his or her consent if he or she thinks that the security will support the rescue of the company as a going concern. There are also certain prohibitions and offences under the Act which make it illegal for the directors to authorise the company to enter into a market contract, a financial collateral arrangement, the granting of a market charge or system charge, a very narrow definition of market type contracts, again, which are provided for under the Act. And if you have any questions in relation to that, do please get in touch with us. We'll be happy to talk through those excluded type contracts. There are also restrictions on the sale of the property, so which property the directors can sell, which property the directors are prevented from selling unless they conform to certain requirements. So if the directors of the company in the moratorium wish to sell assets, free assets, so assets that are not subject to charge, then they can only do that if the sale is in the ordinary course of the company's business, that the monitor consents to the sale, it will support the rescue of the company as a going concern, or with the court's permission. And again, if the property is subject to the charge, subject to a charge, a floating charge or other charge, again, the directors can only sell that asset if it is in accordance with the terms of the security, or where they've got court's permission, and the court's permission will only be given, again, provided that the proceeds of the asset is distributed to the secured creditor, where the creditor has valid security over that asset. In relation to hire purchase property, so property in the company's possession under hire purchase can only be sold if it is, again, in accordance with the terms of the hire purchase agreement, or it's sold with the court's permission, and the court will give permission if the net disposal proceeds are applied in discharging the sum owed under the hire purchase agreement. So the restrictions on, there are also restrictions on the payment of some pre-moratorium debts. So these are debts that the company has accumulated before it's gone into a moratorium. Now there's a cap on the total amount of payments in respect of pre-moratorium debts, for which there is a payment holiday that a company can make during the moratorium. And the cap is £5,000, or or 1% of the value of the debts and other liabilities owed by the company to its unsecured creditor, whichever is the greater. So not a huge sum. Any payment over that amount will require the consent of the monitor, and the monitor will only give his or her consent, again, if it supports the rescue of the company as a going concern. So you will see from the types of, those three categories of restrictions I've talked about, that you might be wondering, well, what type of pressure, if any, can you exert for your debt where you want to collect that debt from a company that it has gone into a moratorium? And at the moment, given the various measures under the Act, and also other measures in other pieces of legislation, for instance, the Insolvency Act, it's very unlikely that there is much pressure, if at all, that you can exert for what are termed pre-moratorium debts, for which the company has a payment holiday. And the reason I say that is because there are also prohibitions or additional restrictions as far as creditor and counterparties to contracts with a company in a moratorium is concerned. And these additional restrictions relate to prohibitions on termination of supply contracts. So you might remember under the Insolvency Act already, there exists a prohibition against terminating a essential supply contract. And those measures were introduced to prevent the suppliers of essential supplies terminating that supply contract just because a company went into administration or liquidation or a CVA. What the new Act does is extend that prohibition to general supply contracts, not just essential supply contracts. It's any type of supply contract where the supply of goods and services is involved. Now, the new Act doesn't define what a supply of goods and services contract is, but in the Act there is a position reserved for government to define what it might be in the future. So at the moment, all we can assume is that ordinary contracts for the supply of goods and services are the subject of this Act, and you could not terminate a general contract for the supply of goods and services if the party you're supplying to is in a moratorium. So these prohibitions on the termination of supply contracts apply to supply contracts irrespective of their date. So even if they are in force or were signed up to before the 25th of June 2020, very limited contracts are excluded from this prohibition. And again, they're a very narrow defined category of financial type contracts, insurance type contracts, bank type contracts, where the company or the supplier is a deposit bank, an investment firm, authorised payment institution, and investment exchange, for instance. The prohibition also doesn't apply to contracts between an insolvent supplier and a solvent customer. So if you're relying on, for instance, supply, and you're the customer of that supply, but your supplier has gone into a moratorium, for instance, you couldn't ask that supplier to continue to supply to you. So it doesn't apply to contracts between an insolvent supplier and a solvent customer. A customer is entitled, assuming the contract, assuming your contract provides for this, to terminate if the supplier is insolvent. The Act also prohibits making supply conditional on certain actions, such as payment of arrears or change of supply terms. So you may be supplying goods and services to one of your customers, and your customer tells you that they're in a restructuring moratorium, they're in a moratorium, and they're saying that you can't, the Act doesn't prohibit, the Act prohibits you from terminating your supply contract, and you turn around and you say, okay, well, we want to make the supply conditional upon you clearing down your arrears, making future payments on delivery, and or giving us upfront payments for supply. Those kind of conditions, again, are prohibited by this Act. So I said I would return to the topic of what debts can and can't be paid if the company is in a moratorium. Now, this is quite a key development, because what it does is categorize the debts that the company that is in a moratorium is subject to. So you might have, you might learn that one of your counterparties, one of your customers has gone into a moratorium, but you are owed money by that company in the lead up to the moratorium. And then you are being asked to supply that company during the moratorium. So you're, you know, you've got a number of categories of debt that you need to understand which can be paid, which won't be paid, when can those be paid. And this is all provided for in the Act. It categorises the debts that a company in the moratorium is subject to, and it introduces terms such as super priority debts and the creation of payment holidays for the company that is in the moratorium and doesn't need to pay a certain category of debts whilst it's in the moratorium. So the categories of debt created in connection with the moratorium are as listed. So you've got pre-moratorium debts. So these are debts which you are owed. So a creditor is owed from a company that has gone into a moratorium process before the moratorium has commenced. Then there are pre-moratorium debts for which a company has a payment holiday. So the Act goes on to say that where you are owed money from a company that is in a moratorium and that debt has been incurred before the moratorium has come into force, those debts have a payment holiday. So those debts don't need to be paid by the company in a moratorium. And then there is a category of pre-moratorium debts for which the company does not have a payment holiday. So there's a category of debts that are owing before the moratorium has come into force, but which the company has to pay. And it's a very narrow category I'll come on to explain. And then there are moratorium debts. So these are debts that are incurred during the period that the company is in the moratorium, so that initial 20 business day period that the company is in the moratorium. And then there is a priority pre-moratorium debt. So these are, the latter two categories have been categorized as super priority debt in any subsequent insolvency. So that means if the company, after having been in a moratorium, then goes into a formal insolvency process within 12 weeks of the moratorium having ended, moratorium debts and priority pre-moratorium debts will be paid first out of that insolvency. They are super priority debt. So the Act provides these distinctions in order to establish which debts can be paid during the moratorium, and in the case of moratorium debts and priority pre-moratorium debt, creates this new category of super priority debt relevant in a subsequent administration, CVA or liquidation. So just to say a little bit more about the categories of debt. Pre-moratorium debt, this is any debt or liability to which a company becomes subject before the moratorium came into force. So this will be you're running up a credit balance with your customer, and there's a line drawn once that customer goes into a moratorium, and whatever that amount is up to the date of the moratorium will be a pre-moratorium debt. Also included within pre-moratorium debt is any debt or liability to which the company has become or may become subject during the moratorium by reason of an obligation incurred before the moratorium. So this is, you've entered into a contract well before the company went into a moratorium, and maybe your supply, maybe your goods and services are payable in instalments, and one of the instalments is due after the moratorium has been has come into effect. So that will mean, because you've entered into a contract pre the moratorium, which provides for a liability that the company in the moratorium becomes subject to during the moratorium, that is still a pre-moratorium debt. Then there's a category of pre-moratorium debt for which the company has a payment holiday. So this is again a pre-moratorium debt that has fallen due before the moratorium, or a pre-moratorium debt that falls due during the moratorium. So that category, if your debt falls into those categories, then that category of debt is subject to a payment holiday. That means that the company in the moratorium that owes you that pre-moratorium debt does not need to pay that debt whilst it is in the moratorium. And then we'll look at pre-moratorium debts that aren't subject to a payment holiday. So these are debts in the lead up to the moratorium, which the company has to pay during the moratorium. And of course, the category of these payments that the company has to pay during the moratorium, these categories of debt are very narrow and very defined, and they include the monitor's remuneration and expenses, goods and services supplied during the moratorium, rent for the period during the moratorium, wages and salaries under an employment contract for the period of the moratorium, and redundancy payments. So if you are supplying goods and services during the moratorium, for which the and the liability to pay for those goods and services is incurred during the moratorium, then the company in the moratorium would have to pay those debts. So then we'll look at, I'll just skip us, then we'll look at the moratorium debt. Now, moratorium debt is defined as any debt or liability to which the company becomes subject during the moratorium. So this is for your goods and services supplied during the moratorium. And any debt or liability to which the company has become or may become subject after the end of the moratorium by reason of an obligation incurred during the moratorium. So that's if you've entered into a new contract or new terms with the company whilst it's in a moratorium, and it hasn't paid you during the moratorium, or the liability to pay you is post the moratorium. So then the last category of debt there is called priority pre-moratorium debt. So what is a priority pre-moratorium debt? This is any pre-moratorium debt which is payable in respect of the monitor's remuneration or expenses, goods and services supplied during the moratorium in respect of the period during the moratorium, wages or salaries arising under a contract of employment during the moratorium. And these, so the moratorium debt and the priority pre-moratorium debt are categories of debt that are protected in the event that after the moratorium the company goes into insolvency. So all moratorium debts and pre-moratorium debts for which the company does not have a payment holiday continue to be payable during a moratorium. So I know this, even for me, to get your head around all of this is complicated. I think what I'm trying to bring out in this presentation, and I think what you need to take away, is that there is a red flag should come up as soon as you hear that one of your counterparties is in a moratorium, not in an administration, not in a CVA, not in liquidation, but in a moratorium. And then I think you have to sit down and discuss, give your usual Gowling contact a ring to really understand where your debt falls. What is your debt? Is there debt in the run-up to the moratorium? How has that debt been incurred? Is the company that's subject to the moratorium asking you to continue to provide goods and services during the moratorium? Do you have a choice in that matter? And if you don't have a choice in the matter, which may well be the case, how do you protect yourself? in terms of ensuring that your continued supply of goods and services is being paid for during the moratorium. So I'm not expecting everyone to understand this immediately, but it is just to flag that there are areas where I would expect that you would need to pick up the phone to us and just even to chat through as to where you stand with continued supply and where your categories of debt fall in the moratorium. In general terms, I would expect that the supply for any goods and services that you've supplied up to the period of the moratorium, that will probably be a pre-moratorium debt that is subject to a payment holiday. Goods and services supplied during the moratorium are probably payable during the moratorium period, and then you want to make sure that you keep a track of what happens after the moratorium has ended. Has the moratorium been extended? Has the moratorium been terminated early? Because if it is, and the company then goes into an insolvency process shortly afterwards, then you've got any money that you were owed during the moratorium, you have protections for that money. It has a priority status in any subsequent insolvency. So these are the intricacies that you would need to unravel and try to establish where you are and where you stand in relation to that debt. So just, you know, you might think a lot of rights and a lot of leverage, a lot of pressure, commercial pressure has been taken away by this act. And that is to some degree true. The measures that are being introduced by this act, especially in relation to a restructuring, in relation to a moratorium, are meant to provide the directors and the management team and the business that freedom to decide what it is that they want to do in relation to the company without creditors banging on the door, without creditors taking action. So it is meant to take those leverages, those commercial pressures away from creditors for a period of time. But just to look very briefly at what you might be able to do if one of your counterparties, one of your contract parties is in a moratorium, is there anything else that you can do, that you can consider? And I've just highlighted a couple of potential actions, potential challenges. So a creditor can apply to the court during or after the moratorium on the grounds that its interests have been harmed by something done or not done by the monitor during the moratorium. So this could mean, for example, that you challenge the monitor because the monitor has not terminated the moratorium as quickly as they should have done on the grounds that he or she ought to have known, or as a qualified insolvency practitioner, that the company was no longer rescuable. So that the Act does provide for you to be able to challenge the monitor's actions during the moratorium. The creditor can also challenge the monitor's remuneration. There are, if the company falls into a subsequent insolvency, the subsequent administrator or liquidator of the company can also challenge the monitor's remuneration on the basis that it was excessive. It's also possible for creditors to apply to the court during or after the moratorium to challenge the actions of the directors on the grounds that the company's affairs, its business and property have been managed during the moratorium in a way that's unfairly harmed the interests of creditors, or it's put, or the directors did something or haven't done something during the moratorium that has caused harm to a particular creditor. So there are, you know, it is important that you monitor what is going on in relation to the in relation to the moratorium. There is nothing in the Act. Yes, the Act takes away a lot of your rights for a period of time. But there is nothing in the Act that prevents you from picking up the phone to the directors, asking them what the objective of the moratorium is, whether or not it's going to be extended, how long is the moratorium going to go on for, what is it that they're trying to achieve, are they going to go into an insolvency process? There is nothing to prevent that type of questioning, that type of probing, that type of harassing, if you want, to really understand what direction the company is going in. And it will be important if it's a strategic relationship of yours. You would hope that the company would talk to you before that, but there's nothing laid out in this Act that says creditors have to be consulted or that the monitor has to consult key creditors. But if you find yourself in this situation, there's nothing to prevent you from trying to get information and sort of applying just normal pressure to understand what the purpose of the moratorium is. The other areas where you could also take proactive steps before perhaps the moratorium takes effect is, be aware of, the profile, payment history of your customers, keep on top of their payment profiles, listen to market intelligence as well. I mean, you might hear of other customers who have heard other creditors who have heard about the customer perhaps having difficulties or considering applying for a restructuring moratorium. Just be aware of that. And again, there's nothing to stop you from picking up the phone to the company and asking about what you've heard. Monitor, as I said, monitor the developments in the moratorium, hassle for information, and then look to see whether or not this is causing is this going to have an impact on your cash flows, your ability to meet, continued supply, or having to wait for your debt to be paid after 20 business days, for instance, or if the moratorium is extended for a period afterwards because your debt is subject to a payment holiday. I mean, if you can understand these matters as early on, then you might be able to manage any potential risk that seeps into your business. This Act is new. There's only been one restructuring moratorium that we're aware of since the Act has come into force, and there are a lot of developments still to take effect as this process is used more and more over coming months. We're very happy to talk to you about any aspect of the new Act, any area that you want to prepare for, and if you want some training to your teams, very happy to come and speak to you about that. Do talk to us, do find out more, speak to your usual Gowling contact. Your usual Gowling contact will know the members of the restructuring team and can put you in touch with us. And we work as one team, so we're very happy to help you if needed. Thank you very much for listening. Many thanks.